Every June we're now traumatized by the Supreme Court, are we not? All right, the president who signed the Defense of Marriage Act, Bill Clinton, and then there's the president who wouldn't defend it, Barack Obama. But the president who signed it, he made a statement at the time. He said, "Throughout my life, I've strenuously opposed discrimination of any kind," this is Clinton, "including discrimination against gay and lesbian Americans. I'm signing into law H.R. 3396, a bill relating to same-gender marriage, but it's important to note what this legislation does and does not do. I've long opposed governmental recognition of same-gender marriages, and this legislation is consistent with that position. And the Act confirms the right of each state to determine its own policy with respect to same-gender marriage and clarifies for purposes of federal law the operating meaning of the terms marriage and spouse. This legislation does not reach beyond those two provisions. It has no effect on any current federal, state, or local anti-discrimination law and does not constrain the right of Congress or any state or locality to enact anti-discrimination laws. I, therefore, would like to take this opportunity," said Clinton, "to urge Congress to pass the Employment Non-Discrimination Act," and so forth. "I also want to make clear to all that the enactment of this legislation should not, despite the fierce and at times divisive rhetoric surrounding it, be understood to provide an excuse for discrimination," and so forth. That's Clinton. Anthony Kennedy and the four other justices in the majority, including two appointed by Clinton, called Clinton, not by name, but in fact, a bigot, because only bigots can support the definition of traditional marriage. There's no other reason, according to the court. You have to be a bigot. You have to have animus. You have to be a hater. That's your Supreme Court, 5 justices. So what is this section of the Defense of Marriage Act that's so offensive? Well, let me read it to you. It doesn't exist anymore. Well, let me read to you what it was, Section 7. "In determining the meaning of any act of Congress, or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States. The word marriage means only a legal union between one man and one woman as husband and wife. And the word spouse refers only to a person of the opposite sex who is a husband or wife." Doesn't that sound bigoted to you? Doesn't that sound radical to you? The overwhelming majority of Congress voted for it, and Clinton signed it. That's just horrific, isn't it? All right, there's that. So what did the court do with that? It threw it out. It said, no, the federal government, that is Congress, is not free under the Constitution to make such a determination. Really? You got to be, really? And then, out of the other side of its mouth, it ruled on Proposition 8. And as the LA Times writes, the U.S. Supreme Court ruled that the sponsors of California's Proposition 8 did not have the legal standing to appeal a 2010 ruling against the measure, a procedural act that cleared the way for same-sex marriage in California, but, they add, avoided a nationwide decision. Did it? Did it avoid a nationwide decision? Well, what happened here? Well, what happened here was Proposition 8 was passed by the people of California. And like other propositions that passed and the left doesn't like, they went right to court, fully expecting to overturn it. You see, here's the deal. You can vote for propositions in California and other states, or you can lobby your state legislatures to pass bills. But if you vote a way that turns out that the left doesn't like, or if bills pass that the left don't like, then they completely reject the democratic process and they go right to judicial tyranny. In other words, they want about 3, 4, 5 bites of the apple. And so what happened in this case, the governor, Jerry Brown, and the Attorney General, Kamala Harris, they refused to defend Proposition 8 against groups that were challenging it because those groups had supported them for governor and for Attorney General. Those groups were among their constituency. So they just chose not to defend. And so there was nobody left to defend the decision of the people of California because the governor and the Attorney General wouldn't defend it because they disagreed with the outcome of a vote. And they should have been impeached just for that. But unfortunately, California is a one-party state. And so proponents of Proposition 8 stepped in and said, okay, well, we'll defend it. Somebody has to defend it. An amazing thing happened. They were allowed to defend it, and they defended it all the way at the appellate level, and they defended it all the way up to the Supreme Court, and the Supreme Court said, wait a minute. you don't have any standing here. You can't defend anything. As a matter of fact, because the state, the officials, the highest officials in the state wouldn't defend it, nobody can defend it. Therefore, the district court decision stands, and we are vacating the circuit court decision, the circuit court which had ruled that the private parties could defend Proposition 8. So, in a circuitous route, the Supreme Court ruled that the district court's decision stands, with no ability to appeal to anybody, because the governor and the attorney general wouldn't participate. Now, it's interesting to me that the court didn't find some civil right or constitutional right or due process right or equal protection right in that, because certain individuals couldn't get their day in court to defend what was a proposition that passed. Isn't that interesting? Don't we call that disenfranchisement? No. It can't be disenfranchisement because the liberals lost. Only when they lose are people disenfranchised. So the court essentially completely overlooked that, and by its action, in essence, knew exactly what it was doing. It upheld District Judge Vaughn Walker's injunction against instituting Proposition 8. And in 25 days, marriages will be performed in California of same-sex couples. Now, some people are arguing, some lawyers who claim to be conservatives and constitutionalists, this isn't so bad. And by the way, they always say this. The Voting Rights Act has said, oh, that's not so bad. And this, oh, it's not so bad. Obamacare comes down. Well, they didn't use the Commerce Clause. They used the tax. That's not so bad. Country's going to hell. The court's out of control. And it's not so bad. Reality, people, it's bad. And it's getting worse. Well, this is a victory for federalism because in the Defense of Marriage Act, the first case, they left Section 2 alone. Section 2, in which Congress said that one state cannot impose its will on another state. Well, that already exists under the Full Faith and Credit Clause. But what did the Supreme Court do to that? Well, it left it alone. No, it didn't. It slammed it through the back door. I'm going to explain this via a brilliant piece at Bench Memos at National Review Online by a brilliant man, Hadley Arks. He's a professor at Amherst College. And he's one of the few people who got it right today. So I hope you'll listen carefully, because I can only do this once. And we will link to this, Mr. Producer, on Mark Levin's show Facebook and Mark Levin's show Twitter. Can we do that? He says these decisions, these two decisions, handed down by the court today, affect to be limited in their reach, but they're even worse than they appear. And they cannot be cabined. They lay down the predicates for litigation that will clearly unfold now, and with short steps sure to come, virtually all the barriers to same-sex marriage in this country can be swept away.